Okay, welcome everyone. My name is Ed Lee, and I'm the co-director of the program in intellectual property law at Chicago Kent. And it's my great pleasure to introduce our first speaker at today's BookIT Talks, which is today a combination of two different books, both relating to the internet and both involving authors with direct connections to California, and their books relate to the internet appropriately so. Today's first speaker is Professor Sharon Sandeen of the Mitchell Hamline School of Law, where she is the director of the Intellectual Property Institute, and she is the Robbins Kaplan Distinguished Professor in IP law at Mitchell Hamline. Today, she will talk about her book, co-authored with David Levine, Information Law Governance and Cybersecurity. It's a case book that is intended to be taught at schools, and she will describe the highlights of the book and the particular approach that the book takes to issues related to the law and the internet. With that, I will turn it over to Professor Sandeen. One brief mention I have to note at the start is today's book talks will be recorded for archival purposes, and we hope to have a 15-20 minute period of questions and answers at the end of each session. So for those of you who will be asking questions, your question will be a part of the archived video. With that, I will turn it over to Professor Sandeen.
Okay, well, thank you very much, Professor Lee. I'm very excited to be able to present this book today, and also I'm very grateful for Chicago Kent for organizing these events and featuring books. It's a unique thing that you do, and I think it's a great idea, and I'm grateful that I could present this book. And I'm also happy that I can share the stage, so to speak, with my good friend Eric Goldman. I'm looking forward to his presentation later, particularly since I will be teaching internet law again in the future, in the fall. Okay, so that, as Professor Lee mentioned, the book is called Information Law, Governance, and Cybersecurity. And yes, it is intended as a teaching tool for a class. I'm currently teaching the class this semester for the third time. I taught it as a conceptual class 4 years ago, and then used a manuscript of the book 2 years ago, and now I'm using the actual book. And I think the students like it. I'll see what feedback I get Monday night, which is their last class for the semester. But the important thing about this book, and I hope that any lawyers listening might find value in it also, is that it's not just a book. It's a promising practice area for lawyers for reasons that I will explain. So why is it a promising practice area for lawyers? The reason, I think, is because we live in a world where the collection and creation of data and information by companies has grown exponentially, as this chart shows. And this chart is just dated from 2010 through 2025. We have a situation where companies, large and small, whether they are involved in kind of data mining or not, are just collecting information. A lot of them, I think, thinking that maybe they could find value in the information they're collecting somewhere in the future. And so all of that information has to be managed by someone. And when we ordinarily think about the management of digitized information, of course, we think about IT people and information scientists and so forth. But I think that there's a big role for lawyers to play in the management of this information. And in fact, it's my position that the legal profession has ceded too much ground to non-lawyers in this area, and we need to get more involved. Now, on this screen, I actually prepared this for another talk I gave earlier this year at the Work in Progress IP conference. I'm presently working on a paper concerning trade secrets and artificial intelligence. So I came up with this graphic to basically illustrate the type of information that goes into, that is involved and collected with respect to artificial intelligence. But I thought I could reuse it in this case to illustrate the nature of the information that a company collects. So if you go back to, think back to the screen I showed you about the exponential growth of data, that particular graphic, of course, doesn't really describe where the data came from or what the type of data is. And this is very important from a legal point of view. So in the second category here shown in green, that really reflects how information is acquired, if you would, so to speak, by businesses. Sometimes they're just collecting information that already exists. Sometimes they're creating new information. And sometimes they're borrowing or licensing that information. And the ways in which businesses acquire information, either collected, borrowed, or created, have different legal consequences with respect to them. The bottom row shows, and I'm sure there might be other categories, but a list of categories of, gotta go back. A list of categories of types of information that companies collect. And the important thing to realize about this is companies don't keep this information in these little segregated boxes. There are some strategies for protection of information and for management of information that requires them perhaps to segregate the information into little boxes and manage them differently. But from a kind of high level business point of view, most companies, I think, just think of the mass of information they have and how, from an IT perspective, they have to store it and secure it and so forth and so on. That point of view, however, is not necessarily consistent with how the law dictates how this information should be managed. So the central premise of the book, and in fact, the idea of information governance, and at this point, I should probably pause to say, information governance is something that is coming out of the people that are involved in information management, that are not lawyers. And in my 35 years being a lawyer, one thing I've observed is there's this process whereby something happens, there's a new technology, a new development in business, and the businesses have to start dealing with it first. And then the maybe professional associations related to those businesses start dealing with it second. And then the lawyers start to do it. And then the law professors start writing about it. So there's this evolution always that begins with the business people and the associations that they are associated with, starting to grapple with these problems. So this is what information governance came out of it. And it's basically out of the records management sector of our society, which, if you think about it, is very old. And I'll do a shout out to Eric Goldman, because I know he knows this. His mother was a librarian, highly recognized librarian. And so librarians are one of the first information managers, were one of the first information managers. And also file clerks. One of my first jobs as one of my first jobs, I'm not going to say as an adult because I was only 16 at the time, was as a file clerk. And so there's a lot of professionalism and experience in the records management field that comes into play in this area. But when you superimpose on this area and this the information technology needs, the privacy law and legal needs, then it becomes a much more complex endeavor. But the central premise now, as this information governance idea is emerging and becoming more mature, is that information management and information security, known as InfoSec, should not just be about privacy and cybersecurity. What's needed is a holistic approach to information management. And information governance, which is a particular process that this book tries to teach, attempts to account for the entire life cycle of information from creation to destruction. Now, as I say that, some of you may be aware, but some may not be aware, that there are actually laws in the state and the state and federal statutes that require that specify how certain types of information has to be disposed of, and in fact whether it can be disposed of, and if it is disposed of, if it can be disposed of, when it can be disposed of. And so it's not simply a question of compliance, for instance, with privacy laws or cybersecurity obligations. It's compliance with all the applicable laws that exist with respect to information. And I should also say at this point, because we do highlight this in the book, and this is a shout out to Professor Andrea Manawishan. She has written an article called Cyber, in which she says it's really a mistake to think about information security only in terms of cyber. And I know this as a trade secret scholar. Although a lot of the high profile cases involving trade secret misappropriation concern computer hacking, many of them just involve physical removal of information from a former employer's company. And it might also involve, for instance, use of information that's stored in an employee's brain, So you can't really limit your information management approach to cybersecurity. So the proper approach to this requires knowledge of the many laws beyond privacy and cybersecurity that impact information. Now, one of the difficulties we had in writing this book is that there's no way possible that you could write in a book that you're going to teach over the course of a semester all the laws that have to do with information management. It's just impossible. So what we tried to do in this book is teach not just, we model, we provide examples of the laws, but more broadly, we model how to approach figuring out what the laws are, so that if someone is working in a particular industry, they know what to look for with regard to the information that they're handling. Now, a holistic approach is needed because more than one set of laws, and I have in parentheses, or legal obligations, apply to most information. And the parenthetical references, of course, contract law, which is supported by the laws of the states, but is the actual obligations, of course, are dictated by the contract, not the statutes. And so typically what happens in businesses, although the businesses I've talked to are starting to change this, is they'll have units involved in different parts of a company's information management. And in fact, if you look closely at a lot of companies, this is even at the C-level, they'll have a C-level person who is overseeing, for instance, corporate documents and reportings, for instance, to the SEC. You'll have another C-level person who is responsible for information technology. You'll have another C-level person who's responsible for intellectual property, probably including trade secrets. Another one involved in privacy, and on and on and on. And so I recommend that top level business leaders be involved in all those aspects of information management. But the problem is that a lot of times the laws that they have to comply with and the business interests that they are trying to further are inconsistent. And so choices have to be made. So one of the ideas behind information governance is to facilitate a conversation between these different groups. And as this slide shows, to illustrate bridging of the gap between these different silos so that they can compare notes and make decisions. Now, the people who are working on developing processes for information governance, and one I have a quote from in a minute. His name is Robert Smallwood, who wrote a book called Information Governance, really are pushing the idea that most companies should have, particularly the Fortune 500 companies, should have a chief information governance officer who is responsible for overseeing this holistic approach to information management. And so I anticipate that sort of position will, come to fruition in the future. And I see that as a position that a lot of lawyers with experience in this area could potentially fill in the future. So one of the organizations that's very involved in information governance, and in fact has, and I haven't gone back to check lately, but they of course, predictably, they registered a service mark in the initials IG, is the Association of Records Managers and Administrators, which is now known as ARMA International. And this group has been around for a long time for the reasons I mentioned earlier, because companies have always had to manage their information. And so, as this quote says, information governance is a strategic framework composed of standards, processes, roles, and metrics that hold organizations and individuals accountable. I have to move the little accountable to create, organize, secure, maintain, use, and dispose of information in ways that align with and contribute to the organization's goals. And one of the goals of the organization, of course, needs to be compliance with legal obligations related, for instance, to privacy and cybersecurity. But there's other legal obligations, such as those related to national security and import-export restrictions and that kind of thing. Robert Smallwood has described information governance as IG, or as IG is as sort of a super discipline. And I would agree with that from a legal point of view. And that's what our book is trying to show, is that you can be, and I have a couple students in my class now who are privacy professionals. You can specialize in one aspect of the overall information management issue, but it's important to have a broader understanding so that you can have a conversation with people in other areas and understand what they have to do and what they have to comply with. Okay, so getting to the book, we've organized it into 3 parts. The first part, and so the parts are labeled consistent with the title. The title, of course, is Information Law Information Law and Governance and Cybersecurity. But the first part is information. And so in that part, and I have another screen coming up where I'll go into more detail of the chapters within the part. But in the first part, we wanted to explore the meaning of information and the purpose and limits of information law. And so what's really interesting in writing this book, my co-author David Levine and I, it's very interesting to note that both the terms information and information law are not well settled yet in law. And so we had to scour the sources of information that were available to us and come up with a definition that we thought was workable. We actually apply a pretty broad definition of information. But importantly, and you'll see this on the next slide, there is a difference, and a recognized difference between data and information. And I think that's an important distinction from a legal point of view in many cases. So data may not necessarily equate with information. The other thing that we wanted to do in this section is we wanted to make sure that students were aware of the fact that information law is not just about protection. It's built into information laws, the ones we cover in particular, but other ones are always limitations that are designed to further other interests. And we wanted to highlight that repeatedly because I think that sometimes gets lost in the information discourse. I know it gets lost in trade secret law. The rhetoric of trade secret law is always to think about it as property and, oh my God, it can't be stolen and this sort of thing. When there are situations where the information is not a trade secret, and even if it is, we might want to allow it to be used by others for public policy reasons or First Amendment reasons and so forth and so on. The second part of the book goes into law, the core laws that have to do with information protection. And then the final part, for the teachers who are listening, we designed this part to be kind of a opportunity to mix and match, pick chapters from part 3 because part 3 is really set up based on kind of a business sector type approach, which I'll show you in a minute. Okay, so looking at detailing part 1 a little bit more, it does have 3 chapters, which I already went over. So a little bit. Chapter 1 has to do with, what is information, and goes into kind of information theory. And then chapter 2 asks the question of what is information law. And the final chapter in this part, I think, is the most important because it does bring up the public policy concerns that I mentioned. And I think, we all hopefully know in the information space about the importance of freedom of speech and also of government transparency. I think what's less known is just the right of information diffusion. A lot of people in the United States do not know and appreciate that the Declaration of Human Rights, UN Declaration of Human Rights, includes a provision, Article 19, which states that, in essence, that the importance of the diffusion of information for a lot of important reasons, knowledge acquisition being one, but also in the ability to engage in civic life and be an informed citizen and voter, for instance. And so that's a core value of the world, according to the UN Declaration of Human Rights. And the United States, a lot of people don't know this either, the United States pushed for that in that article after World War II. And they did so because during World War II, the media in the United States was upset about not being able to get enough information from other countries about what was going on in the war. And unfortunately, the United States never, in essence, ratified the Declaration of Human Rights. And it's not self-executing. But if you cobble together a lot of principles that exist in US law, not just under the First Amendment, but in a lot of IP cases, for instance, Bonito Boats, Kiwani, Sears Compco, you will see this strong public policy in the United States for information diffusion. And so we definitely wanted to highlight that and as a counterbalance to information management. Now, chapter 2 is probably the heart of the book because it goes through, it actually teaches students and exposes students to what we consider to be the core law having to do with information management. And I included a quote on the slide that is very important to me. It's included in a lot of cases, but the basic principle is information is not protected unless the law says it is. And it is only protected to the extent that the law provides for such protection. And this is important to consider when you think about the graphic earlier and the amount of data and information that companies are collected. The mere fact that they're collecting it doesn't mean it's protected by law. And I know they want it to be protected by law. It's kind of the Lockean labor theory. We collected it, so it's ours and it's protected. But because of information diffusion purposes, that's never been the law. And as a practical matter, companies can protect that information. They can keep it secret and secure. But if it leaks out, they may not have a cause of action. And that's important to know because the mere fact that they collected it doesn't mean it's protected. So what's shown on the screen as far as the chapters, detail the main ways in which information is protected. It can be protected through contract law, through information ports, and we highlight trade secret law, copyright law, and the common law privacy torts in chapter 5. The next 3 chapters are really about privacy and cybersecurity and privacy and data protection. But we broke them up because if you look at most privacy statutes, you look at the GDPR, for instance, or the California Consumer Privacy Act, they will have these 3 parts to it. Kind of like what is the basic obligation? Well, what is the information that is protected? What is the nature of the information security that is required with respect to that information? And then what are the consequences of any sort of data breach? And so we wanted to highlight those 3 areas and provide an opportunity in the book to go deeper into privacy and cybersecurity than we might have gone for the other topics. And that's by design. I had a guest speaker speak to my class at the beginning of the semester. And he also was an advisor to me as David and I were writing this book. And he actually practices in this area. His name's Robert Kadanak from Dorsey and Whitney in Minnesota. And, whenever I hear him talk, and in fact, whenever I hear anybody who's practicing in this area talk, 90% of the conversation is about privacy and cybersecurity. I think that as this field matures, that number will go down and there'll be more consideration for these other issues because I think it's necessary. But that's why we highlighted those 3 chapters. We also included a chapter on information crimes to make it clear to the people who will be engaged in information management that the improper handling of information in some circumstances can lead them to be prosecuted for a crime. And obviously they need to know that. And then chapter 10 is of course related to the earlier chapter, chapter 3. But in this particular case, it contains a discussion of the actual laws that seek to implement the information diffusion principles. And, Eric's favorite being the Communications Decency Act of Section 230, which he's going to talk about in a bit. But we also have, of course, fair use and First Amendment issues, and also whistleblower provisions, which are a big part of trade secret law. So the final part of the book is titled Governance. And it begins in chapter 11 with an overview of the information governance process. Some of you that are in attendance might be familiar with the cybersecurity processes that are often illustrated as a cycle where you have to kind of identify the information and then, secure protection and then test it and then make changes. Information governance has a similar concept to it. It's designed as an ongoing, if you do it right, it's designed as an ongoing process that's always improving and evaluating what's going on within a business. So we introduced that in chapter 11. And in fact, the this semester I'm teaching this course as a seminar, so I'm not able to talk about chapters 12 through 16. We just can't get to it. But I do highly recommend that at least this book be taught through chapter 11, because it does introduce the actual process. Chapters 12 through 16 were designed to be illustrative of the way in which information management issues and law arises in different settings. To illustrate that, if you go to work for any company, I don't care what company it is, if you go to work for a paint company, you have to go, as a lawyer, you have to go research the law that has to do with paint related information. And so that's what we're modeling here. But if we chose to focus on those topics that students would, except for national security, that students would have already been somewhat exposed to in law school. So for instance, corporate documents and information, they would have been exposed somewhat to the filings that are required by the Securities and Exchange Commission for publicly traded companies. When you think about it, that's all about information management. What you have to produce, what sort of information you have to produce, when you have to file it, who you have to file it with, how long you have to keep it, who has access to it. That's all about information management. The litigation, of course, students would be exposed to it in civil procedure, but this goes into issues like litigation holds and protective orders and things like that. Government transparency concerns, of course, David Levine's favorite topic, Freedom of Information Act and related issues regarding public access to government-held documents. We included a chapter on national security because we thought it was important to highlight, given its connection to cyber security concerns. And then the final chapter I thought was important to include, because whether anyone taking this class becomes an information governance professional or not, they will be lawyers, hopefully, all of them. And lawyers have information governance obligations. The rules of professional conduct, for instance, require us to be up to speed on technical advances. And so we are required to be aware of cybersecurity threats. We're required to know how to properly store documents. We're required to know how to properly dispose of documents and return them to clients when we close our practice or leave one firm and go to another. And so that's all about information management. And we wanted to provide that as an example of how this works in the real world. So I'm ready to hear questions if there are any.
Great. Thank you, Professor Sandeen. If you have a question, please use Zoom to raise your hand and I will call on you. Maybe I'll start things off by asking a question. Well, first of all, let me just say this is an impressive book which covers, you and your co-author have done a tremendous job in assembling a wide variety of different issues that intersect with information governance. So it's quite impressive. I'm going to sort of pick one topic within that world, though, and get your views on it. You mentioned Article 19, and you mentioned information diffusion as being an important sort of right, or in addition to, I guess, value. I guess I wonder how that intersects with misinformation, which is more what Eric's going to be focusing on with Section 230. But since misinformation is such a hotly debated issue with respect to the election, with respect to COVID misinformation, how does that fit in within the notion of a right to information diffusion? And relatedly, sort of like, is there a way to navigate if different countries have different approaches to whether certain misinformation is illegal or illegal under their laws? How would you situate misinformation within this sort of broader context?
Well, that's a good question. I think that, at least in theory in the US, I think the US Supreme Court, most of the justices would say that more speech is better. It's the availability of information and more speech and available that allows people to figure out when information is true and not. And so I think that idea then is consistent with what I'm saying, is that we need to have this balance in all these areas of information law. And I can take, for example, trade secret law. The example I often use in courses is, and I've written exams on this or hypotheticals where, a company pollutes a lake and they and the pollution is discovered, but the government regulators and the nearby citizens want to know what the pollution is. What is the, what was put in the water? And the company might say, well, that's a trade secret, And so here's a situation where the desire to keep the information secret is conflicting directly with the need for the information to figure out what it actually is. And you can also see that during the time period before that information is shared or disclosed, that there's likely to be a lot of misinformation that could harm the public, or could harm the company that's not sharing the trade secrets. So I think it's all tied together. But I certainly acknowledge that a problem with information diffusion is that sometimes the information is not accurate.
Okay, let me just double check if there are other questions. Please raise your hand. I do have a somewhat, I guess, related question in terms of at least the information governance side of things. In terms of copyright infringement, in terms of misinformation, content moderation, I think there's a common thread of the scale of there's just so much information involved, and companies have to rely upon artificial intelligence, automated review, the robo notices for DMCA, et cetera, or whatever. And for misinformation, algorithms tracking misinformation. As that becomes, I think, the norm, given the scale of content online, what sort of adjustments need to be made? You mentioned the chief information governance officer. That may be in name, but maybe, it's the algorithm that is really sort of running the show in terms of, copyright, DMCA notices and content moderation, et cetera, whatever. Like, how can companies sort of maintain control when they're ceding a lot of the review to automated systems?
Yeah, a good question. I mean, I think this ties back to the comment I made earlier about how, I mean, there are companies that we know of that their whole business model is dependent upon collecting information and then monetizing it. But there's other companies that fall in the category of, I'm just going to collect information now because I might be able to monetize it in the future. And of course, companies that are developing artificial intelligence type systems, I think they fall somewhat into that category. They might, oh, well, maybe in the future I could do some sort of AI thing. And so I need to gather all this data. And so the problem well, let me go back. So one of the things I think about information governance is it requires a more fine-grained approach than the approach of just gather as much information as possible and figure out how to monetize it. Because there are legal consequences that come from holding certain information. And I like to tell a story of a local attorney at a company in Minnesota who suffered a data breach and wasn't really on top of information management. He would admit this at the time until this not a data breach, it was a trade secret misappropriation case. And he said, he ordered then a holistic review of the company practices. And one of the things they decided to do is that certain information they wouldn't even collect anymore. They wouldn't even keep anymore, because keeping that information exposed them to more liability than the information was worth. And so with respect to the automated systems you're talking about, Ed, I think that that we have to look at what is the data that comprises, that is fueling those systems. And we have to think fine-grained about it and decide, for instance, whether that information, to what extent that information is going to be protected, to what extent that information has to be shared, to what extent that information has to be verified. And I see that as the future of information law is that kind of discussion. And so with regard to a lot of the automated systems that are being developed, there's concerns about bias that is built in, and that we need to then be able to see the underlying data and be able to verify its accuracy. And I think that can be done without necessarily knowing what the algorithm is that, is used to generate the results, to a degree. So I think that's what we're going to have to start doing. And it will be interesting to see how that develops.
Okay, terrific. Let me see. Are there any other questions? If not, we should all thank Professor Sandeen for her fascinating discussion of this book, Information Law, Governance, and Cybersecurity. It's an impressive book covering a range of issues related to internet information governance, as you can tell from today's presentation.